Hi guys, it's Kathy. I hope you're doing well. So we're going to a couple courtrooms today. We're going to hang out with Judge Eric for a while because I love him and because there's a lot of tears. So please get your tissues ready. Very, very, very sad. It's a very sad case that I will not be laughing at because that would be rude. And then we're going to go to Indiana. We might have time for Maricopa. I'm not sure. I have Maricopa ready just in case we get there. But, all right. Let's go. Let's go to Eric. Oh, before I go to Eric, thank you all for commenting and liking any comments on posts and videos and shorts. I'm really trying to be way more professional here. So it really helps. I think it's helped a lot. I mean, my last short did really, really, really well. So thank you. Thank you for helping me.
Hamler, Mr. Hamler. All right. 25 CR 957, number 78 on the court's docket, People versus Hamler. Entries?
Daniel Cohen on behalf of the people.
Ben Britton on behalf of Mr. Hamler, who appears out of custody in person at the podium to my left.
All right, set for arraignment today. What are we doing?
At this time, we'd be entering not guilty pleas, requesting a jury trial of 12.
We want to get over a week because lawyers are changing?
Given
Or 2 weeks? If you want to set it, you can set it, but he's leaving, so you're going to get a different lawyer.
Yeah,
You can set it on his calendar, but then we come in 2 weeks.
just not trying to not fill up the docket, but I guess that could be the opposite.
It's all right, the 16th was not very full. It's going to be incredibly light that day.
We can do the 16th.
All right, continued arraignment, June 16th, 2025. You'll hopefully meet your attorney before that date. By the very least, you'll meet your attorney on that date, and we can figure out how we want to move forward. So you want 8:30 or 1:30? 1:30? 1:30 in the afternoon on the 16th. We'll see you then.
And Your Honor, we do have something to address something
hold on.
before Mr. Hamler leaves.
Yes.
Your Honor, in the interest of full transparency, Mr. Hamler was recently contacted by police for violating the protection order.
I wasn't contacted by the police.
Okay, sorry, let me make this clear. There was police were recently called for a violation of protection order, the protection order arising from this case. Police did conduct an investigation. That investigation has been submitted to my office for the filing of charges. It does appear that Mr. Hamler has violated the protection order. At least there's probable cause to believe he has violated the protection order by going to the house that is directly next door to the victims in this case. And from what I can understand, there may be other instances where this has happened. I told Mr. Britton that I have held off on filing that case. It was submitted last week. I haven't filed it yet because I wanted to talk to Mr. Britton first about the possibilities of whether it needed to be filed or if there was going to be a resolution that would perhaps encompass that case. But that is something that is coming down the road. I can submit to this court that there is probable cause to believe that there has been a violation of the protection order. The victims are incredibly upset by the fact that he has been pretty regularly at the house next door to them, which is the scene where this happened. The victims, in fact, are present. 2 of the 3 victims are present in court today to be heard, well, at least to talk to me and to make sure that this is addressed. My recollection was that at a previous court date, I had made it very clear that the house that this incident occurred at is within that protected area, and he should not be going back to that. I also looked back in the notes from this case, and when Mr. Hamler was first advised on February 16th of 2025, And when the mandatory protection order entered, he told the court that he would be residing with a cousin elsewhere and not at the normal residence, given the area restrictions for the GPS. Sounds like as soon as the GPS came off, Mr. Hamler went back to that house. I have concerns that Mr. Hamler is disregarding the protection order and it is disrupting the lives of the victims and causing a problem. At this point, I would ask the court to strongly admonish Mr. Hamler that he is not to be at the house that is within 100 yards of this victim's house and is an area that the victim is known to be, that he abide by the protection order, and I will tell Mr. Hamler that that case will be charged soon, and I will work with his defense attorney to work on a time that he can turn himself in on that offense. And the one of the listed victims is present. As I mentioned, she would like to address the court if the court would hear from her.
Yes.
Okay.
My name's Angie Valdez.
Okay, what would you like me to know?
I just like to know, all of this stemmed actually from the defendant asking me and my family for help during an incident with his girlfriend. I run a nonprofit out of my house, and it's made me very leery about helping people after this. And even sitting in the back just a few minutes ago, he proceeded to turn around and look at me and ask me, "What are you talking about?" And the fact that he does that blatantly right here in this court, knowing he's not supposed to have any contact with us whatsoever, it really, really bothers me. And the fact that
And the fact that he was just about to walk out the door. The judge said, "Okay, I'll see ya."
been over there all of this week. I have pictures of him. I can't go in my backyard. I can't take my trash out. My daughter can't come and work with me at my nonprofit. She hasn't been over to my house by herself since then. I think he has no regard for this court or anything that they address him to do, and it scares me so much. I was told he's not a resident at the house next door, and I don't see why he should be allowed to go over there if he's not a resident. It scares me. It scares my daughter. And the fact that he can turn around and try to address me in this court when I'm sitting back there, it really, really worries me. And that's just all I'd like to say.
Thank you. Appreciate that.
This judge gets mad, very mad. Now he has to think about everything first. I'm going to go get myself a cup of coffee while he's
Certainly.
Be right back.
Court has been presented with evidence that appears that he's violating the mandatory protection order that I've issued in this case.
Your Honor, and it sounds like the prosecution has been presented with evidence to file a case. That has not been filed at this point.
I'm not worried about the case. I've got my bond. And the condition of the bond is to have no contact and comply with the no contact order.
And I do understand that, Your Honor. This is a very unique situation, and I'm sure the court has seen disputes between neighbors that are highly contentious.
He's not a neighbor. He's over at a house he doesn't live at.
Yes, but this is much more akin to a neighbor dispute situation, given the relationship that he has and that residence. At this time, I don't believe that there is sufficient evidence to show that the protection order has been violated. I don't believe that there's allegations of any sort of violence or any community safety. He has a daughter who resides at that residence that he needs to be involved with and has been doing everything he can to facilitate abiding by the protection order while also having custody and exchanges of his daughter. I can let the court know that during his time on GPS, there were no warrants, or I'm sorry, there was no complaints filed by pretrial services. He was spending money out of his own pocket to be in a hotel so that he wasn't violating his protection order. He has been doing everything he can to comply with the protection order. You know, being completely candid with the court, I think that Mr. Hamler is an expressive person, and sometimes that could come off like gesturing at or towards somebody. However, while being in this courtroom, have not seen anything that indicates that he is trying to express or communicate or do anything to intimidate or be in any way aggressive. I think that it is appropriate to not revoke his bond, to keep everything as set, allow this to proceed forward with the request of the people for a strong admonishment.
I don't admonish. My job isn't to yell at people. Moms and dads admonish. I've got a mandatory protection order that says stay away from at least 100 yards away. As soon as I take the ankle bracelet off, you're back at the house. This is a situation where you threaten someone with a gun. You're going to be remanded. I'm revoking the bond.
Your Honor, can I please say something? Please?
Sure.
I stay around the corner, Your Honor. I don't be over there. I go get my daughter from...
You're not supposed to be there. You're not supposed to be within 100 yards of them, sir.
At the apartments on Colfax. My wife, my wife drops my daughter off at the hotel for me. For real, Your Honor. I don't...
We'll have a hearing on the matter on the 16th.
My wife finna come up here and get my stuff. Can she please come up here and get my stuff for me, please? I haven't done anything.
As far as I'm concerned, she can, if it's okay with the deputy.
Your Honor, please. I would, please.
Your wife can grab your belongings if you would like.
Can I please put your stuff over? Can I please get another shot, Your Honor? Please. I have a 2-year-old daughter at home.
Look, sir.
Please.
You should have been thinking about this when I told you stay away from the house.
I never do nothing.
I am advising.
Please, Your Honor. Please, I'm begging you.
We'll set this for a hearing on the 9th.
Please, I got a whole daughter, Your Honor, that needs me at home. Please, Your Honor.
Best way you can be with your daughter is to comport with the orders of this court and do not violate restraining orders that are meant to protect victims. You may give your belongings to your wife if that's all right with the...
Can I see her before I get in there, please?
We will set this for a hearing on the 9th and we'll discuss this.
Please, can I see my wife and my daughter before I go back there, please?
You're going to be remanded at this time, sir.
Please. No, baby.
We'll release the bond. We'll set bond in the amount of $20,000 surety.
No.
Would the court consider?
And it will have GPS on it again. What's that, counsel?
I'm sorry, Your Honor.
You said something?
I was going to ask if the court would consider a 10% option on that.
Absolutely not.
I used some tissues. That's why I was gone.
All right, this gentleman is.
But he was crying.
Is Mr. Hauser next?
Sorry, who?
Okay.
I'm sorry, the gentleman's name?
Hauser next?
I'm sorry, I can't hear.
Number 90 and 91.
'23 CR 6217, 24 CR 2827, People versus Aumi.
Tom Walton for the people.
Member written on behalf of Mr. Azume, who appears in person in custody at the podium to my left.
All right, I've got appearance on arrest warrant in both cases. Looks like he...
Three guards just went out to the wife. Nothing happens. I'm just
Looks like-
saying what I see.
Judge Arnold's issued a warrant on May 20th. He failed to appear. Is that right?
Correct, Your Honor. I'm
And then
happy
the
to.
matter was transferred back. Or were we just waiting for competency issues?
Correct, Your Honor. So procedurally, I raised competency. This got set in 1H on the 20th.
I have competency issues.
Unfortunately, I was in trial in this courtroom that week. Mr. Azame did try to call me to inform me that he was sick and likely going to be in the hospital. I did not receive that message, being kind of enveloped in trial until after the fact. So there was the failure to appear. It sounds like it's being represented to me that he has paperwork from the hospital that can prove this. I would need to get that. However, I do, given his record of appearing in court every time that I've been here and he's been set, have full confidence that this is accurate and truthful. I would be requesting this court reinstate the bond, asking to give him another opportunity to attend.
Not without evidence, that won't.
Okay. Court, either way,
So,
being reset in
I
1H.
guess we are no, I'm not resetting in 1H. We're gonna order a competency evaluation. We'll set the matter for June 30th. For review of competency.
Says Godiva chocolate. Oh, I wish I had some right now. This much Godiva chocolate to go with my cup.
We'll vacate the trial that's set for July 15th. We'll vacate the pretrial in the 24-2827. We'll convert the pretrial on June 30th to a review of competency at 8:30. All right, so I'll see you back on June 30th. The doctor's going to come see you. They're going to do the competency evaluation, and we'll see you then. If there's evidence of anything about the hospital, it can be presented to the court in support of a motion, and then we'll go from there.
You Honor, I have the paperwork. That's it that I want to do. After my neck was killing me really bad. Even until now, I'm still sick. I can barely walk. My knee and my back is hurting.
Same.
Looks like bond has already been set in both of the cases.
I have the,
If you bond out, does he need to reapply, or is he already qualified?
He is qualified.
All right, bonds have been set. We'll see you back on June 30th, sir.
June 30th, okay. Let's go there. Sit down.
June 30th, settings of your release.
Okay.
Yeah, if we call the case for Mr. Avila Morales.
All right, number 72 on the court's docket. 23 CR 3941, People versus Avila Morales. Entries.
Daniel DeCecco for the People and covering for Bilal Aziz in,
Wait a minute, we have two cases, sorry. There's also,
yeah,
sorry, we also have 24 CR 3774. Now entries.
Daniel DeCecco for the People covering for Bilal Aziz in the 3774 matter.
Ben Britton on behalf of Mr. Avila Morales, who appears in person at the podium with me on bond to my left.
So if you're in Discord in general right now, Bobby just commented, gosh, I hate how the legal system works, although people don't want to admit it. And it's interesting because probably all of us will, in fact, admit we don't like the legal system how it is. It should be changed. But then when you ask people how it should be changed, we all want something outstandingly different. So some people will say, you know, that we should be way harsher. Just no more paroles, no more pardons, no more probation. You know, if you commit a crime, you go to jail, you stay in jail until you're done, and then you get out. Other people would say, yeah, it's just, we need to rehabilitate more. We need to not punish, but rehabilitate, and only punish people who can't be rehabilitated. And then other people will say, well, it shouldn't cost money. Money shouldn't be a factor. And other people will say, yeah, we should make them pay. Like they should pay. They should work while they're in prison, and their money should go to, you know, something we use our taxes on right now. I bet you we are all so outstandingly different in how we would change the legal system, which is why it doesn't get changed, because I guess right now it's sort of, I guess it's not balanced, but it's balanced. It's balanced.
All right, we've got resentencing and sentencing. So the party's ready to proceed?
People are ready.
And defense is
Defense?
ready.
All right, go ahead, Mr. DeCecco.
So in the 24 CR 3374 matter, I filed a restitution request in the amount of $5,348.98, which just asks the court to grant that or set for hearing if there's an objection. I understand there was a stipulation to probation in that case that was negotiated. With regard to the 23 CR 3941 case, I would ask for a community correction sentence. The defendant was non-compliant with treatment, had substance use issues on probation, committed this new law violation. I will note the Adams case was dismissed, but this was an F5 attempt strangulation. Very serious how he did not do the domestic violence treatment. This DOC would be appropriate here, but given the substance abuse issues, I think ComCourt is an appropriate sentence to balance the needs for containment and treatment. I know that's tricky if he's getting probation one case, ComCourt another case, but I think there's lots of ways the court could do that. Or if he wanted to revoke his probation with jail time if the court did impose a community
How, Monica?
correction sentence.
So you wanted me to give him Concord in one case while giving him probation in another case? I think if global offers are going to be, got multiple cases, I think we're going to have to reconsider what kind of promises we're making to get pleas.
And the stick to probation was a surprise to me, but I understand the reasons why that was the agreement.
What's going on with Adams County?
That was dismissed.
Bertie Madoff went to jail. Don't get arrested. If you do, please cry and scream as they take you back.
Yeah, when I negotiated the disposition in the 24 CR matter and it was contemplated to a stipulation to probation, I know that I had conversations regarding the revocation case. And it was my understanding, although I can't find an explicit in writing note, that there was going to be a reinstatement of probation, or at least a request for that. I think that in a situation like this, that's an implicit understanding, and that the other options are just not really feasible. I know that the people have suggested that one option would be that the court impose ComCore, and then there's a self-revocation or probation, and it's jail sentence that gets imposed and it's concurrent. But quite frankly, that just seems to lose the benefit of the bargain and the point of negotiating to a plea like this. My request would be for the court to honor the stipulation by the parties in the 24 CR matter, impose a probationary sentence, and also my request would be to reinstate a probationary sentence in the 23 CR matter, understanding that the Adams case has been dismissed, and understanding the seriousness of the underlying allegations in the 23 CR matter. I do believe that given the nature of the revocation with the dismissed Adams case, and then the resolution of this case with a misdemeanor class 1 and class 2 misdemeanor, I think that it's appropriate. But frankly, I think that imposing a community corrections sentence offers less structure and less oversight and less of an opportunity that if the concern is having control of any sort of substance use issues or having any sort of availability of domestic violence classes for the 23 CR matter, having that support isn't going to be the same coming through community corrections as it is giving another opportunity on probation. I think that
You see, they moved his camera again, but we can't see the gold man. Maybe when they move it again, we will.
negotiating to a stipulation to probation in the 24 CR matter shows that what at least the previous district attorney was looking at is the rehabilitative purposes of probation and what can be offered in this situation. I I mean, it doesn't make as much sense in my mind to sentence to community corrections knowing that there's not a chance that the stipulation of probation is going to be honored. So now we're in a world of operating under legal fictions, or I guess not even legal fictions, but alternates to what was contemplated, negotiated to, and agreed on by the parties in the 24 CR matter.
Go kill some foxes, gather me some dandelions, and bring me one chalice. I'm a server. I don't think I would get money while in jail. I would be screwed. And then, Micah, if I finish 3 quests, you can give me this tiny little bikini outfit as armor. As armor to go fight the dragon. I saw people on Naked and Afraid build bigger pieces of armor clothing than they do in most video games. I like that he ponders a lot. I like it.
So you're there, tell me you think you'd like me to know before I sentence.
I just want to say that I would appreciate the chance on probation again. I understand that I didn't complete the domestic violence classes, but I did enroll and I did start them. I ended up having to go to jail in Jefferson. That's why I never got back into treatment. I just got out. I'm doing okay. I'm doing better. I've been sober for the past 5 months, and I want to give it all on probation this time around because I want to complete it and get done with it. I have a job. I have a stable job now, so I just want to get this opportunity one last time.
Well, I agree with the defense on this one. I think this is something got missed by the prosecution. And you agree to stipulate to probation in the new case, and I think it's inappropriate to ask for something more than probation in the older case. Not, sir, that you did not earn that. This is the second time you're avoiding prison. This is the problem with me accepting stipulations.
He hates caps. He hates steps. He hates it. He keeps telling these lawyers, I don't like caps. I don't like stipulations. You guys prosecute and I will judge what should take place. Me, not you guys. And this is what happens.
You should have gone to prison the first time. You should be going to prison this time. Make no mistake. You pick up another case, I will not be accepting any stipulations, and you can bank on going to prison on this DV case. Am I clear?
Yes, sir.
You violate because of drug use. You wash out of treatment. You violate my probation and you are going to prison. Period. I don't care what the DA says. It's up to me to sentence, and you will be going to prison. I do not want to put you in prison, but you have absolutely earned it. You deserve it. And now you have the ability to stay out of it. 3 years of probation concurrent in each case. You will have all the original terms and conditions from the 23 CR matter and the 24 CR matter. Like I said, that will be also 3 years concurrent. No drug use. Get all your treatment done. No new law violations.
Your Honor, I think the purpose of the sentence can still be invoked by the court, but there were solely misdemeanor charges in the 24 CR case. I think limits the term of probation to 2 years.
That's why there's a misdemeanor of a limit of 2 years.
Yo, you're going to set this judge off. You're going to go back there with the other guy crying. Just stop trying to limit this judge. He does not like it. Anyway, you're about to get legally slapped down, sir. You did it to yourself.
I know DUI does. I don't think an M1 has a limit of 2 years. If I'm wrong, let me know.
For some reason, I thought it got amended to 2 years. I guess it's been a minute since I.
I stay pretty abreast of what the legislature does. I don't recall anything limiting probation to 2 years. When 3 years of probation in each case concurrent. If I'm wrong, you let me know.
Essentially, it's the same. I just wanted to make sure it wasn't an illegal sentence.
Correct. Thank you.
Yep, that's exactly right. They're both pondering now. They're trying to figure out if a
All right, you need to
misdemeanor.
report to probation tomorrow. 303 West Colfax.
Yeah.
I will order the restitution. I think that was,
I thought it was 50, like,
where is that one?
100. How did it go to 5,000 now?
50,000.
You mentioned 5,000 earlier.
It's in the 24 case?
And that should be somewhere with that. I'm pulling it up, but I thought that was like 1,100.
$1,713.98.
Yeah.
All right, that is ordered in the 24 CR 3774.
For additional.
Is there?
Someone was out on vacations.
We all need him, Mr. Allen.
All right, any objection to the 534898?
Your Honor, at this time, I have not had ample opportunity to review the amended worksheet, but I would object. I can.
All right, objection's due in 2 weeks. If no objection is filed, the $5,348.98 will be ordered. If the objection is filed, ask for a hearing, and we'll go from there. I think as of today, because the legislature governor did sign a bill today, I think we're now at 63 days. So we'll get everything done within 63 days.
I don't know if you got the things I sent you.
I have not gotten any.
Okay, well, I'm in the map program. She was trying to reach out to you.
All right, the gentleman is.
Mr. Rasmussen.
So, I think get out of here. So, had to do it properly.
There he is, number 57 on the court's docket. 24 CR 6046, People versus Rasmusen.
And Ben Britton on behalf of Mr. Rasmussen, who appears in person in custody at the podium to my left.
All right, we're set for sentencing. The party's ready to proceed.
Yes, Your Honor.
Yes.
Any additions or corrections to the PSI?
None from the people.
Not from defense.
Mr. Walton?
Thank you, Your Honor. It looks like there is $4,038.25 requested in restitution. I think the PSI reflects that Mr. Rasmussen pretty much completely fails to take any responsibility for his actions that led us to this. We would be asking for the max 3 years DOC.
Hi.
What happened in Douglas?
Yeah, and I believe I have a note of credit for time served. I'm just trying to see when that was imposed.
It looks like it.
No idea. But I'll get it back.
I've got the case number wrong. Is it Douglas County? Is it? What was the case number?
24 CR 873.
There it is.
You don't like that background? I shouldn't have made it bigger then, huh?
Mr.
What about
Britton?
that green thing? You don't like that? like that?
To start with the PSI, I disagree with the people's characterization of the amount of responsibility taken. I think that it's clear that in the following paragraph, from what I believe the people are referring to, Mr. Rasmussen clearly indicates that he believes all of this is a part of his drug and substance abuse issues, that he believes that that is very much a problem for him, and that's something that he wants to take responsibility for. He has expressed multiple times in that PSI his interest in some sort of treatment court, drug court, something that is a structured program to allow him to address those issues. I think that this often presents where somebody appears to not be taking responsibility when it seems like there's other issues going on that they're taking responsibility for, and then there's the underlying act, which, you know, there's context and circumstances about. In this case, Mr. Rasmussen understood that he was paying for and renting a U-Haul for 30 days. He had it for 7 additional days. That constitutes a motor vehicle theft, and he has pleaded guilty to it and admits that there's a factual basis there. But I think that it's reasonable to understand how somebody could see why that's minimized from honoring a 30-day contract and then keeping a vehicle longer than you should. That's not to say that he's not taking responsibility for it at all. He clearly understands that if he weren't under the influence of drugs or had this sort of issue.
I think any normal person, if they rented a car for 30 days and they did not take it back in that 30 days, would know that that's grand theft auto. Like, I don't know any person who would say, oh no, I'm just a few days late taking the car back. I wasn't stealing it.
This wouldn't have happened, that he wouldn't have violated that agreement and essentially committed a motor vehicle theft. Given all of that, and given his readiness to accept kind of treatment and everything else, since he's been in custody, he was enrolled in the MAP program, he's met with them. They've set him up with Hazelbrook as a sober living home for when he finally does get released from whatever custody status he does.
If it's a library book, or if it's one of those rent-to-own refrigerators, or other things that you borrow. But a car? I don't know. A car is different.
It is something that is the paramount consideration for Mr. Rasmussen, getting sober, that is. The court can see in the PSI the letter that he wrote as a written statement that his main concern right now is taking care of his daughter. He understands that he's too old for what has been a pattern of conduct based on drug abuse and substance abuse. Given all of that, obviously, treatment court, given what he has pled to, is not an option. Divert, I should say. I do believe that should the court impose a 3-year sentence, he has over 100 and some days credit for time served right now. It's going to be a very quick turnaround. He may still have an opportunity to go to Hazelbrook very quickly, but ultimately it would be maybe more of structure and more of an opportunity for real rehabilitation should this court consider the option of probation or release with a condition to Hazelbrook, so that he can get released from here without having to go through the DC process, get paroled, and then establish that. So ultimately, defense's request would be for a probationary sentence with drug treatment, evaluation, and everything that can be imposed, including a condition of sober living and treatment at Hazelbrook.
Well, he's not been accepted into Hazelbrook.
Fill out the applications with the MAP program.
I can't, or you're asking me to do a fiction. That's not an ask.
And that's fair, Your Honor. I think
He's never
that
going to do it.
possibly the court could condition some. No, that's fine.
Yeah, I can do 3 years. I can do 3 years ComCore. I'm going to give you 3 years community corrections, credit for 165 days. You want to, it's going to be a secure place. You're going to have a place to sleep. You're going to be given treatment. It's everything you're telling me that you want.
That'd be great. I want to be sober.
So we'll see how that works out for you. The downside is if you walk away or you And it's not a perfect program. It's got its issues. If you, get kicked out of the program, it just converts to DOC.
The structure will be good.
All right, anything else you want to tell me, sir?
Yeah, that's I appreciate the help.
All right.
It's something I need.
All right, well, good luck to you. Good luck to you. 3 years of community corrections, 165 pre-sentence confinement credit. Now, the other downside with ComCore is there's a long wait. You're going to sit in county a while longer, waiting for a bed to open up. You said you've already done the MAP program?
Yeah, I'm in the MAP program right now, Your Honor.
Okay, well, continue with that. Is that part and parcel with RISE or?
They just enrolled me in second chance. I'm waiting to get into the MAT unit,
Okay,
and they're just, second chance should be coming out sometime this week to see me, and they enrolled me in a 2-week treatment program when I get out, if I want.
okay.
And then they have me a sober living for Longmont set up.
All right, well, use your time productively so you get off on a good foot when you hit ComCore. Good luck to you, sir.
Thank you, sir.
And just to clarify, Your Honor, is the restitution ordered?
Oh, sorry, where was that? Still impending?
I think it's too much.
I don't even see it impending. Any objection to the restitution?
I would. Sorry, I'm just pulling up the plea. I can't remember if this was a stipulation to it in the plea.
No.
Keep saying that word stipulation. This judge is going to get you.
Looks like it was.
Yeah, give me a stipulation.
So he said it before. This judge. He doesn't have to conform with their stipulations or their caps. He doesn't have to. But his problem is, and what he told them was, all the other judges in Colorado do. They go by it. If they have an agreement, the judge follows it. More or less. And he's like, you guys are making me the only judge who doesn't follow your stipulations and caps. I hate them. You guys should not put them in at all. That it should not be part of your deals at all to cap, because it's not your decision. I think, and we're going to be watching him, I think he is going to start ignoring them because he doesn't like them. He doesn't like the way they are half the time. He thinks they're wrong. And he keeps telling them, warning them, that I don't like this. I do not like when you do this. Please stop. And they don't care. So I think this judge is going to start pissing off a lot of lawyers soon. And maybe the other judges will start doing what he does.
From the plea. No objection.
$4,038.25 to Hall is ordered. And that's what the restitution form says. All right, good luck, sir.
Thank you.
Mr. Gonzalez did finish that 5 minutes.
All right. Get this gentleman done, and we'll get Mr. Gonzalez. This is who?
Mr. Romero?
Romero. Oh, there he is. 25 CR 907, People versus William Romero. Entries?
Tom Walton for the people.
Ben Britton on behalf of Mr. Romero, who appears in person at the podium with me to my left.
All right, set for arraignment today. How are we proceeding?
Your Honor, normally this would be a request to enter a not guilty plea and get those dates set, given the status of counsel. I would be requesting for a 1 week reset so that we can get this all sorted out and figure out the trial calendar it's going to be going on to.
All right, we'll reset it for June 16th for continued arraignment at 8:30. Is he not in custody in this case? He is.
Should be.
All right. 8:30 on June 16th. We'll see you then, sir.
If you like this judge, you can only see him here. No other channel is going to play Eric like I do. So make sure you subscribe or you're going to miss out on more Judge Eric.
Mr. Gonzalez, you got that paperwork?
Yeah, good, Your Honor.
You may. All right, 25 CR 381, People versus Gonzalez. Mr. Cohen for the prosecution. Mr. Gonzalez is present pro se. This case is currently 131 days old. February, he had the public defender application pending. In March, we found out he did not qualify. He was looking for private counsel. In April, he came back in and still had not had private counsel, so I continued it again, but told him if he did not have counsel, we'd at some point have to start looking at him representing himself. And today he still has no attorney. So at this point, you will be representing yourself. Because really, it's not so much a decision as it is a necessity. You don't qualify for the office of the public defender, right?
You know, I didn't. I was
Yeah,
on
and
the margin, and then
I've given you 3 months to hire an attorney. So we just kind of have to move forward.
yeah.
Now, if you have the ability to hire an attorney,
There any way, like,
what's that?
is there any way I can get help, like getting an attorney?
Well, I mean, I'm sure when you didn't qualify for the public defender, we talked about this. You got the low pay, slow pay list.
Yeah.
And so that's all the help we can do is we work with the bar, find out who's willing to, charge less, sliding scale, payment plans. And so you just got to go through that list.
He won't.
What we'll do is we'll set this matter for an arraignment. Gives you more time to try to get yourself an attorney. Gives you time now, since you're representing yourself, to talk to the DA, find out what they're offering. And then you can choose to enter into an agreement, or you can choose to set trial. But in the meantime, for now, we'll set this for July 21st. You want 8:30 or 1:30?
I prefer mornings, 8:30.
All right, well, now that you're representing yourself, we can get you called up a lot faster. All right, so the arraignment is at 8:30 in the morning on July 21st. Make make sure, if you want, make sure the DA has your phone number, email address so that they can send you offers, talk to you. Make sure you know who the attorney is on the case so you know who you're talking to. Just remember that anything you say can and will be used against you. So probably shouldn't talk about the case, make admissions, things of that nature. But otherwise, if there's an offer in the case, they can give you that offer and you can decide how to move forward. Of course, like I said, you've got another 6 weeks here. If you can get yourself an attorney in the meantime, then if they walk into court with you, I'll gladly let them represent you. All right, see you on July 21st at 8:30.
Your Honor.
All right, this is
Mr. Biggers, number 5 and number 6.
all right, 23 CR 694, 25 CR 1048, People versus Biggers. Entries.
Daniel Cohen, BF People.
Ben Britton on behalf of Mr. Biggers, who appears in custody at the podium with me to my left.
All right, so we've got a disposition in the 1048 matter. No motions have been filed, so we will vacate June 6th. And we already have trial set for October 14th. Just remember the pretrial conference is set for September 30th, and that is the last day that I will accept a plea that does not include count 1. And I guess we're trailing the 23 CR matter.
That is correct, Your Honor. I would request, if the court isn't way too overset at this time, a status date on the 16th, where a few other cases have been set for the substitution of counsel.
We came in today with only like 26 on the docket that day, so we might be up to 50. It's still going to be super late.
Okay, then I would be requesting a status date. As new counsel reviews the case, if there's any issues, I'd like to have these things on track and not having the court have to put a bunch of fires out when it gets closer.
All right, status June 16th at 8:30. You'll get to meet your new attorney at that time. And
I'm sorry, Your Honor, what was that date?
the 16th.
Thank you.
And if you're going to accept an offer, then we can do it on that date. Otherwise, we've got our pretrial and trial dates. All right, have a good day. All right. Is this Mr. Moore or Mr. Wassam?
Mr. Moore.
'25 CR 1230, People versus Moore. Entries.
Tom Walton for the People.
Josh Lindell on behalf of Mr. Moore, who appears with
83.
me, who appears with me on bond.
Sorry about that. Getting Andrew up to speed. Where are we? All right, I have reviewed the PSI. It is dated May 19th. Any additions or corrections?
No additions or corrections.
Nothing from the People.
Mr. Walton?
Thank you, Your Honor. Your Honor, the facts of this are somewhat concerning, particularly the fact that the gun on Mr. Moore was itself stolen. Mr. Moore does have a fairly significant history of convictions, if most of those are just misdemeanors and failures to register. This, in my view, presents kind of a difficult decision between probation and community corrections from the people's eyes. A probationary sentence with a jail sanction, particularly if it allowed Mr. Moore to participate in RISE or another drug-related treatment program, would probably be a good result here and get him treatment and supervision. At the same time, the stability provided by community corrections might also be an appropriate route. We'll defer to the court between those two.
So a request on this matter for a probationary sentence. Mr. Moore, as far as diving into the facts of this case, there was a small amount of drugs involved in this. This was for personal use. This is not a situation where Mr. Moore was dealing. He absolutely has a gun, admits he had a gun. He did not know it was stolen. It was just a purchase down the line. He was headed into the mountains, was concerned about mountain lions. It was for self-protection. He knows he has a felony conviction. He cannot have a weapon. However, this is the first time I believe he has actually interacted with the possession of a weapon by a previous offender.
Judge, it was for a mountain lion. That's what it was for.
Statute and had been in this position. He understands the seriousness of it and that for the rest of his life, he cannot own a firearm. As far as where he's at right now and why we believe he'll be successful on probation, he has a much more stable place to stay. He was essentially living out of his car at the time. At this point, he has worked with some friends and has a room with them. It is a house here in Denver, so he has a more stable place to stay. Additionally, he is working. He's working with Weaving Games, essentially helping intake folks and do signing up for sports betting. However, he's looking for longer term work in the mountains right now in a variety of fields. And he has some interviews lined up next week for that. Additionally, in this matter, Mr. Moore has faced some pretty significant punishment just by the virtue of the arrest and the seizures that happened alongside that. He lost his service dog. He has a service dog for seizures. They were claimed by the police department in this, and he has been trying to track them down since he got out of custody and has not been able to. Additionally, he has represented to me that the cash that he had in the car, as well as several accessories for electronic devices were not in the vehicle when he was able to, or when he was able to access it. He was able to get some of his goods out of that vehicle while he was out of custody in this period. However, he did lose the car itself. He was not able to pay for it. So it was a situation in which Mr. Moore has been substantially punished in this matter. In addition.
Okay, no. You don't lose your car and your house if you're in jail for 24 days. I mean, you would have already had to have been 6 months behind on everything for them to take your car and your house for being in jail for 24 days.
He's done 45 days in the downtown detention center here, so he has 45 days of credit. I think we're in a situation where Mr. Moore is not going to be around firearms. I think he is in a much more stable position in his life, and that probation is going to give him just that last extra level to ensure we do not see him anytime in the near future. It's going to continue that support and supervision in the community. He has been extremely communicative with me and is just a really good planner and has been really taking this case seriously and trying to set himself up for success since he's been out of custody. To my knowledge, has had no new law violations, no contact with law enforcement, no issues on pretrial, nothing like that. He realized this is really the window I get to prove myself, and I'm lucky to even have that. And so he's asking for an opportunity to continue that trust on probation.
So you're really telling me anything you'd like me to know?
I would just like the opportunity to keep working forward and moving forward and dealing with this step in my life and getting everything right back on track.
At least get him his dog back.
Well, I got to tell you, you're hanging out at the Circle K at 2 o'clock in the morning. You didn't have a gun and drugs because you were going into the mountains. This isn't about mountain lions.
I believed him, Judge.
Excuse me.
Maybe the judge doesn't look extremely angry, though, does he? He's pondering
Now,
again.
your juvenile history is your juvenile history as an adult. Really, other than the failure to register, you've got the drugs. And in this case, you've got drugs and a gun. You know, if you're going to keep lying to me and lying to your attorney and lying to yourself and talk about this being about mountain lions, then you're not going to fix the habit. And you're going to end up in prison. You're going to have to start being honest with yourself. I'll give you the opportunity at probation on this case, but you need to know you pick up another charge and you violate, you don't do treatment, we're skipping ComCore. This is it. This is the chance you asked for. And if you don't take advantage of it, we're just going to do prison and be done. We clear?
Yes, sir.
All right, 3 years of probation. Substance abuse evaluation and treatment. You may not possess firearms. Firearms not going to help you with a mountain lion anyhow. Even if you were going out there camping, by the time you see the mountain lion, they're on you. You're not shooting the mountain lion. Although it's a funny way to end the day. So like I said, substance abuse evaluation and treatment, no firearms, don't pick up any new law violations, do the treatment that you're supposed to do, finish the probation and move up into the mountains and have yourself a nice quiet little life. Otherwise you come back in front of me on a revocation, we know what's going on, right? All right, you need to report to probation tomorrow. They're closed today, so go to 303 West Colfax tomorrow. Can you do that?
Yes, sir.
All right, good luck.
Like the people have filed a motion for protection order terms. So I'll just go ahead and enter the mandatory protection order.
Guys, back up a little bit. Don't get too close to this guy.
So, Mr. Bush, this protection order will stay in
Mr. Bush is very dangerous.
place until final disposition of the action. If you violate a term of the protection order, the sole term, you can be found in contempt of court or charged with a new crime of violation of the protection order. In either event, you can be fined, imprisoned, or both. And that protection order states that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you're charged with. Do you understand that protection order, Mr. Bush?
I do, but I don't even know who the person is.
All right. Okay, so Mr. Bush, do you want an attorney for the bond hearing, or do you want to waive your right to an attorney so that you can proceed to a bond hearing today? I will let you know.
Proceed to a bond. I want to get out of here. Let's proceed.
Do you want to waive your right to an attorney for purposes of the bond hearing then?
Yes, ma'am.
All right, we'll go ahead and move on to bond hearing. Ms. Bench, what's your position on bond?
I'm giggling a little bit.
Thank you, Your Honor. The people are asking for a $5,000 cash only bond in this case. The people believe that Mr. Bush is a danger to himself and to others. The people also believe that this likely will be upcharged to second-degree assault on an officer in custody. I do believe that the penalties are slightly different.
Lock him up.
That this is assault 3 on a peace officer, but as I previously indicated, will likely be upcharged to second-degree assault on an officer. The people are asking for $5,000 cash only based on his
Double that.
current failure to comply with bond in his current pending felony, which is 25 CR 17. The people had previously imposed a $1,500 cash only bond, which Mr. Bush then posted and promptly failed to appear at the beginning of May, I believe. The people opposed quashing that warrant, and I believe the court agreed and did not quash the warrant in that case in, again, 25 CR 17. So the people believe, given that pending case for which Mr. Bush is currently on bond, as well as the facts in this case, again, that Mr. Bush is a community safety risk, both to himself and to the community at large, particularly any officers whom he might encounter, and are requesting not only the $5,000 cash bond, but intensive pretrial services with monitoring should he post that bond and or if the court does not agree. Thank you.
And Ms. Bench, I'll just let you know that pretrial services is denying any sort of supervision whatsoever on for Mr. Bush.
That makes sense.
All right, Mr. Bush, I'm going to ask you a number of questions before we get to your position, okay? Again, the people are asking for a cash bond. So first of all, how long, or do you live in Delta, Colorado?
I live in Cedar Ridge in an RV.
All right, and how long have you lived in Cedar Ridge?
28 years.
Okay. And are you currently employed?
No, ma'am, I'm on Social Security. I make $1,000 a month.
Do you currently have a vehicle and a driver's license? All right. Do you want to let me know
Thank
that the
you,
people are
Kay.
arguing that you're a public safety risk and a risk to yourself?
I am not a risk to myself, and I'm not a risk to the others, actually. Unless I'm mistreated or forced in one of these Mickey Mouse suits here, then I become a risk. I don't like to be put or bound up in a straitjacket. I don't think anybody would. I've never been a day in trouble in my life, Your Honor. You can check that. These charges, when we do go to trial, they will get dismissed.
Okay, Mr. Bush, anything else you want to tell me about why you think you're not a public safety risk?
Public safety risk. I've never
Or a
been
risk to
sued
yourself?
in my life. If I wanted to hurt these gentlemen or these people here, I could have. To be honest with you, I happen to have 2 black belts. I studied for 40-some years. I have never struck an officer. Not a single one. The only thing I did was stiffen my body and made it more difficult for them to move me from one location to another. But I have never struck an officer, have I? Well, they're not
All right,
gonna-
thank you, Mr. Bush. All right, in consideration of the people's argument, as well as taking into consideration the fact that the defendant has lived in Cedar Ridge for approximately 28 years, he has a driver's license, it doesn't appear he's a flight risk. The court does have concerns, however, that he has an open case at 25 CR 17, which is the allegations include a DF4 on which he's on bond. Additionally, the underlying allegations of this case include assault on an officer. Therefore, the court does believe that there is a public safety risk with regards to Mr. Bush, and the court does not find that the court can put the defendant on conditions of bond that would alleviate these concerns, because the pretrial services is denying supervision for Mr. Bush. As a result, I'm going to grant people's request for a cash bond. I'm not going to issue a bond at the level that is being requested. I am going to issue a bond in the amount of $2,000 cash only. That's slightly higher than the cash bond that he's on with DF4. Conditions of bond will include, I'm not going to be ordering that the defendant comply with pretrial services based on pretrial services denying any supervision. The only conditions of bond will be the protection order and no further conditions of bond at this time. Okay, so Mr. Bush, did you want an attorney to represent you in this case?
Yes, ma'am.
All right. Do you think you'll be able to bond out on $2,000 cash only?
I have no idea. I haven't spoke to my daughter. They
Okay.
won't let me speak to anybody.
So as long as you remain in custody, an attorney will be appointed to represent you. If, however, you do bond out and you want the public defender to represent you, you'll need to apply.
Yes. That's who's representing me currently in the other.
Okay. So it sounds like since you've got a
Go.
recent case, you may not have to submit a new application for the public defender to represent you if your last application was it within the last 6 months. That said, why don't you go ahead and do that? If you do bond out, just check in with your public defenders to see if
One in Taekwondo, one in Kung Fu, whatever. That's normal. It's a thing.
you need to reapply in this case, okay? Do you have any questions about that?
No, ma'am.
All right, we'll go ahead and set your case over. I'm going to set you over fairly quickly just to check in and make sure that you were able to get a public defender on your case or whether you're remaining in custody. We'll set your case over for just a moment. We'll set your case over for June 10th, and that'll be at 2 p.m.
I won't remember that.
June 10th at 2 p.m. I'm sure one of the deputies will write it down for you. Anything further on this case, Ms. Bench?
No, Your Honor. Thank you.
Mr. Bush, any questions for me?
I don't think so.
All right, thank you. We'll move on to our next case. We've got Ms. Swallow who just logged back in, so I'll call case number 25 CR 87, People versus Thomas
You
Anglam.
see how nimble he is? He has 2 black belts. Watch. Watch his nimbleness and his speed.
All right.
His agility.
We'll move on to our next case. We've got Ms. Swallow who just logged back in, so I'll call case number 25 CR 87, People versus Thomas Anglam. And Ms. Swallow appears via WebEx, and Mr. Anglam appears in custody from the Delta County Jail. And Mr. Anglam, did you want a court-appointed counsel to represent you for purposes of this hearing?
Yes.
All right, I'll go ahead and appoint Ms. Swallow to represent you. And Ms. Swallow, are you in a position to waive further advisement in this case?
We would so waive.
All right, and Ms. Swallow, have you been able to speak with Mr. Anglam about whether he wishes to waive extradition or not?
I have, Judge, and our request today would be to waive extradition, but we would be requesting bond pending extradition pursuant to 1619-117.
Okay, just a moment.
That was my cat. Don't worry, I fix it. But that was my cat. After the 20th time I told her to stay off my computer.
Hey, Mr. Wynn. Oh. Come on up. You want to take up Mr. Blower? Absolutely.
I don't know where this judge is from. Is this Michigan? I think I got a Michigan judge today, guys. It's very exciting.
Case number is CR 0323 7875. Mr. Glauer is present in court with his attorney, Mr. Wynn. We have Ms. Price from the prosecuting attorney's office with us. And the parties have entered into a non-binding agreement with the court, plea agreement. And it appears that it's going to be.
No, it doesn't. No, it doesn't. No, it doesn't. No, tinfoil stops cats. When my son went to college, I bought a whole bunch of tinfoil, and I covered the stairs going down to the basement and the entire basement floor, and the bed, tinfoil. I tinfoiled everything. I tinfoiled it like up a little bit, so here's the stairs. I went up the sides of the walls so they couldn't like scoot around it. No, they didn't care one bit. They did not. I'm telling you, they did not care 1 second. They all just went down there. Dog too. The dog went down there too.
Count one, the state was going to dismiss part 2 of the information, and its sentencing recommended period of probation. Fines, fees, and court costs were left to the discretion of the court. Now,
Your Honor, the amended count 1, I believe it's a typo. It should be just count 1.
Should be just count 1. That's good news, because I was wondering that. So he's going to plead guilty to possession of methamphetamine?
Correct. I emailed Mr. Wynn to let him know I didn't believe the amendment was right, but I didn't dare change the plea agreement since it's been signed already, so.
So, Ms. Price, do you have a motion with regard to part 2?
We would move to dismiss that.
Court will grant that motion upon accepting the plea of guilty, count 1. Mr. Glauer, is that your agreement?
Yes, Your Honor.
Okay. And just to confirm with you, Mr. Wynn, that's the agreement?
Yes, Your Honor.
Okay. Now, Mr. Glauer, before we go down that road, let me ask you a few questions before we begin. Of course, Your Honor. You indicated that you've been diagnosed in the past with depression and ADHD?
Yes, Your Honor.
Okay. And it looks like you're taking Prozac and Adderall?
Yes, Your Honor.
Have you taken those medications within the last 24 hours?
Absolutely.
And do they affect your ability to understand what you're doing here at all?
Absolutely not. They're actually very beneficial.
They're helpful. That's a yes?
Yes.
Okay, I'm sorry. All right. Have you consumed any other controlled substance or alcohol in the last 24 hours?
No, Your Honor.
Is there anything at all causing you difficulty understanding why you're here?
No, Your Honor.
So, sir, I'm going to allow you to withdraw your plea of not guilty to count 1 of this information. That simply means that there's no plea on the record. Are you prepared to enter a new plea today?
Yes, Your Honor.
So, to the charge of possession of a Schedule II controlled substance, methamphetamine, what is your plea? Guilty. Now, before I accept your plea, we need to go over the guilty plea questionnaire together. Did you fill out this document in your own handwriting?
Yes.
And did you have Mr. Wynn available to answer questions for you?
Absolutely.
Your signature appears on the back page of the document. To the best of your knowledge, was it filled out true and correct?
Yes, Your Honor.
Mr. Glauer, you give up some important constitutional rights when you plead guilty. And I see on page 1 and 2 of the guilty plea questionnaire where you reviewed each right and initialed by it, indicating that you understood what right you were giving up. Is that correct?
Yes, Your Honor.
Now, this is a non-binding agreement on the court. You understand it, right?
Yes, Your Honor.
So that means that the only person that can promise you what sentence you'll receive is me, right?
Of course, Your Honor.
And you also understand the maximum penalty that could be imposed could be up to 7 years in prison.
Of course, Your Honor.
Now, other than this written plea agreement, have there been any other promises made to you to get you to plead guilty today?
No, Your Honor.
Has anybody coerced you, or threatened you, or coerced you to do this against your will?
Not at all, Your Honor.
Are you satisfied with the representation of Mr. Wynn? Did you discuss with him the facts or
Thank you,
circumstances
Jude.
of this charge? Yes, sir, we did that one. And did he explain to you the elements of the charge and what the state would have to prove in order to obtain a conviction? Very thoroughly, yes. So just to confirm for you, this is a possession charge. And on question number 34, it asks if there was going to be a license suspension as a result of the guilty plea. You answered yes to that question, but the answer is no. Okay, there's no license suspension then. I was unclear on it. It's okay. I just wanted to make sure you understood that. Thank you so much. I appreciate that. Just to confirm, Mr. Nguyen, he didn't answer these two questions because I think it's because it's not real. Is that right?
Yes, that is correct.
All right. So questions 57 and 58 refer to an Alfred plea. He didn't answer those questions because it's not. Going back to the information, Mr. Flower, do you admit that on or about July 27th of 2023, here in Bannock County, the state of Idaho, you unlawfully possessed a Schedule II controlled substance, methamphetamine? Yes, Your Honor. Now, do you remember the facts of what happened there?
Yes, you know, at the time I was using, I don't recall that particular amount being in my vehicle at the time, but of course, that's relevant because in Idaho, if it's in your car, you're still charged with it.
So
I
apologize. Okay, so let's start from the beginning. You were contacted by law enforcement.
I was pulled over by law enforcement leaving Winco grocery store.
Why were you pulled over?
I actually had stopped at a friend's house right there, close to a couple of the bars over here. But anyway, a detective, plainclothes detective in a unmarked vehicle followed me. I had no idea. And I stopped into Winco, bought a bunch of groceries, and she had called two uniformed officers to pull me over as soon as I got in my car in the parking lot. I go to the parking lot, they follow me. I got down to the Maverick right there on Jefferson, and they pulled me over. And
they explained to you why they pulled you over?
Not particularly at the moment, no. They did, you know, pull me over and then expressed to me that my registration was out on the vehicle. So they had a justification for it.
Okay.
And like I said, at the time I was using, I don't recall that amount being in my vehicle, but hey, it was in my possession and I was using.
So let's say
I'm guilty of the situation.
Okay. Let's start. What happened next after they said your license was, your registration was expired? What happened next?
They also informed me as well that they wanted to search the vehicle. And I just informed the officers, well, to my knowledge, there's nothing in here. But I think that it was later on that the plainclothes detective walked up and threw her badge over her neck and continued to explain things to me from there.
So let me ask you a question. Did you consent to the search?
I actually do not recall consenting to the search, but there again, you know, it's all about the discovery. It's all about the body cams, anything we need to find out information like that. I don't personally recall agreeing to it, but.
Okay, so let me ask you the next question.
Yes, sir.
Was methamphetamine found in the vehicle?
Yes, sir.
Okay. And did you know that it was in the vehicle?
Again, I don't recall that it was, but it was in my possession and I had been using it at the time. So
okay,
I'm guilty of it.
So you have no reason to believe that it wasn't yours and that you believe it was methamphetamine? That's a yes?
Yes, sir.
Mr. Nguyen, any issues that you had with the stop and subsequent search?
No, Your Honor, and based on the police report, it was indicated, and I believe it was also in the body cam, if I remember correctly, that it was a consent search, so they searched based on Mr. Bauer's consent.
Thank you, Mr. Nguyen. Based on that, Ms. Price, does that meet all the elements of the crime?
Yes.
Mr. Nguyen, any legal reason I shouldn't accept the plea?
No, Your Honor.
All right, Mr. Blower, I'm gonna accept the plea.
Guy tried to answer every single question in the most lawyerly way possible. Judge still got him to admit it.
Being knowingly and voluntarily given that there is a factual basis for the plea. I'm going to set your case for sentencing on July 28th, and I'm going to order a pre-sentence investigation report to be prepared. Ms. Price, do you have any objection to his continued release?
No, Your Honor.
I'm going to continue your release with your promise that you'll stay in contact with Mr. Nguyen to comply with all conditions of your release, including one extra one. Is that you cooperate with the pre-sentence investigation report and meet with them as required. Can you do that?
Yes, sir. I'm actually out on bail right now, though. But yes, I'm more than happy to see them and whatever I need to get handled with them as well.
So the important thing is to maintain contact with Mr. Nguyen. And the next most important thing is not to miss any appointments with your pre-sentence investigation.
Yes, sir.
If you can do those things, you're sound, okay? Anything else we need to take up in this matter?
No, Your Honor, but can I get that sentencing date one more time?
Absolutely. July 28th, 2019.
Okay.
Ms. Price, anything else?
I don't believe so.
So Mr. Blotter, meet with Mr. Cummings behind your right shoulder there, other shoulder, other right. Okay. And then you can go, okay?
Thank you so much.
Very much.
So at this point of my day, getting content, I fell asleep. So whatever happens in the next 39 minutes, I have no idea. And we're not going to watch it all, but we'll play a little bit more just to see maybe the yellow guy or the yellow guy. Who knows? Who knows?
So Mr. Wait, let's take a Gerald Tilman.
Yes, sir.
Tilman, could you unmute your tablet for me?
Okay, I got it.
This is State of Idaho versus Gerald Tilman. Case number is CR 0325-3404. Mr. Tilman is joining us through video conference. His attorney, Mr. Nguyen, is here in person, along with Ms. Price, the prosecuting attorney's office. Parties have entered into a plea agreement, non-binding of the court, where Mr. Tilman would plead guilty to count one of the information, count two would be dismissed. The courts, the state would recommend a zero determinate sentence and a 5-year indeterminate sentence to be served, and that all fines, fees, and court costs will be left in the court's discretion. Is that the agreement, Mr. Williams?
Yes, Your Honor.
Mr. Tilman, is that your understanding of the agreement?
Yes.
And Ms. Price, is that your agreement?
It is.
So,
Well, someone's mad.
you have a motion regarding count two, Ms. Price.
This time, Your Honor, I move to dismiss count two.
The court will grant that motion upon accepting a plea of guilty to count one of the information. So, Mr. Tilman, before we go any further, I need to ask you a few questions. Look, you're really good. So, Mr. Tilman, looking at the guilty plea questionnaire, you indicated in there that you've never been diagnosed or treated for a mental health disorder. Is that right?
Yes, that's right.
You're not currently taking any prescription medications, are you?
No,
Have you consumed any controlled substance or alcohol in the last 24 hours?
no,
Is there anything causing you difficulty understanding what you're doing here?
no.
Sir, I'm going to allow you to withdraw your plea of not guilty to count one of this information. That simply means that there's no plea on the record. Are you prepared to enter a plea today?
Yes,
And to the charge of battery on a law enforcement officer, what is your plea?
Guilty.
All right, now before I accept your plea, we need to go over the guilty plea questionnaire together. Now, did you fill out this document in your own handwriting?
Yes.
And did you have Mr. Nguyen available to answer questions that you might have had?
Yes.
Your signature appears on the back page of this document. To the best of your knowledge, was this filled out true and correct?
Yes.
Now, Mr. Tilman, you give up some important constitutional rights when you plead guilty. And I see on page 1 and 2 of this document where you reviewed each right and initialed by it, indicating that you understood what right you were giving up. Is that true?
Yes.
Now, you understand that this is a non-binding agreement on the court, right?
Yes.
And that the only person that can promise you what sentence you'll receive is me. You understand that?
Yes.
Now, that doesn't mean I won't go along with this plea agreement, but it's something I have to decide after I get a chance to look at a pre-sentence investigation report, okay? You understand that?
Yes.
Okay. And if I understand correctly for you, is looking at your cases, you've got a parole violation pulled, and you'll end up topping out that sentence around the end of May 2027. Is that accurate?
Yes.
Okay. And that's the whole purpose behind the 0 fixed 5 years indeterminate. Is that right, Mr. Ward?
Yes, Your Honor.
Ms. Price, I'm assuming that's why you entered into this agreement.
I believe so, Your Honor.
And do you know if there's any restitution with regard to this case yet?
I have not had that confirmed at this point, but I have a note to ask the victim witness coordinator to follow up.
Okay, thank you. All right. So other than this written agreement, Mr. Tilman, have there been any other promises made to you to get you to plead guilty today?
No.
Has anybody forced you or threatened you or coerced you into doing this against your will?
No.
Are you satisfied with the representation of your attorney?
Yes.
And did you discuss with him the facts and circumstances of this charge?
Yes.
Did he explain to you the element of the charge and what the state would have to prove in order to obtain a conviction?
Yes.
Now, I recognize, we already talked about this, that you're on parole. And of course, you understand that this potentially can have an impact on your parole status, right?
Yes.
More importantly for me also is that you understand that this charge is a new case, and I want to make sure that you've discussed with your attorney the difference between a concurrent sentence and a consecutive sentence. Have you done that?
Yes.
You understand the difference between the two?
Yes.
And you understand that I could impose a concurrent sentence or a consecutive sentence, correct?
Yes.
All right, thank you. Now, here's a really important question that you answered that I really need to talk to you about. It's question number 45. And 45 has to do with you being able to review and discuss the evidence with your attorney. And you said you haven't had enough opportunity to review that information and discuss it with your attorney. Is that how you wanted to answer that question?
I don't know, because I can't see the paper, so I'm getting confused right now.
So you haven't.
Well, Your Honor, if I may, so we did, he wanted and should have by now received actual physical copies of the discovery. He answered no to that at the time because he indicated for whatever reason there had been an issue where they hadn't gotten to him in the jail that should have been rectified. I indicated to him that we would just answer that no, he hadn't reviewed it personally himself. At that time, and we take it up to date, he should have received copies and shortly thereafter, perhaps the next day after we filled out the guilty plea advisory form for him to review personally himself. Well, we had gone over the documents, he just didn't have physical copy.
Okay, so Mr. Tilman, have you got those documents yet?
Yes, I did get them. That's the part where I got confused.
Let me ask you this, do you feel comfortable with proceeding still?
Yes.
Okay, so you've reviewed them, you've had a discussion with Mr. Nguyen, before you got those. You feel okay with proceeding with your guilty plea?
Yes.
Okay. Did you have any questions you need to talk to Mr. Nguyen about before we proceed with this guilty plea question?
No.
Great. Now, the other question is number 46, and maybe this relates to what Mr. Nguyen just explained to me. It says, do you want your attorney to take any further action in this case? Does that reflect back or go back to when you need to look at the discovery? You need to have him provide you with the evidence, the paperwork?
Yes.
Is there anything else you need him to do before I accept your plea of guilty in this case?
No.
Thank you. Now, Mr. Nguyen, I just need to ask you a question of 56, 57, and 58 have to do with the plea itself. And is this an Alford plea?
It is an Alford plea, mainly because, and I did talk to Mr. Courtroom about it, it's really an issue of him not being able to having any independent recollection of the event. He indicated that to me that I believe he was intoxicated to the point that he can't remember what happened. So he can't provide his own factual data.
Well, thank you. So, Mr. Tilman, let me ask you that question. So, you don't remember what happened, is that right?
Yes, I don't have no recollection of what happened.
Because you were under the influence?
Yes, I was sleeping in back of a car, and my wife, she got pulled over, and I didn't even know we got arrested.
Okay, and so you went over the police report with Mr. Nguyen, right?
Yes.
All right, and you don't disagree with what they're saying happened, is that what you're saying? You're saying, what you're saying is that based on the evidence that would be presented to a jury, you're willing to plead guilty under Alford, is that right?
Yes.
All right. And you understand that by making an Alford plea, it's just the same as I have to treat it just like a guilty plea. You understand that?
Yes.
Okay. Now, question number 59 asks, are you having trouble answering any of these questions which couldn't be resolved with discussing it with your attorney? And you answered yes to that question. Have all your questions now been answered?
And what?
Sure, that's okay. What I'm asking is, you answered no, yes to a question where you said you were having trouble answering the questions in the guilty plea questionnaire, and you are struggling with it. So are there questions in the guilty plea questionnaire that you're having trouble answering?
Oh, no.
Okay, and so you were able to talk with your attorney and resolve any questions there might have been?
Yes.
Okay, thank you. All right. So going back to the information and understanding that you're pleading guilty under Alford, do you on or about March 24th, 2025, here in Gwinnett County, the state of Idaho, you willfully and unlawfully used force and violence against the person of Nicholas Evelyn by kicking him, and you knew or had reason to believe that he was a peace officer at the time you committed this battery while he was engaged in the performance of his duties. And you're admitting to that based on the police report and under Alford, is that correct?
Yes.
Based on that, Ms. Price, does that meet the elements of the crime?
Yes.
And Mr. Nguyen, any legal reason that should be accepted?
No, Your Honor.
So, sir, I'm going to accept your plea as being knowingly and voluntarily given, and that there is a factual basis for the pleas. Now, I will tell you up front, I'm inclined to perhaps accept this plea agreement, but there's a few things I still need to look at before I do that. One, if there's any restitution, and two, I would like to review a pre-sentence investigation report to see whether or not it would be appropriate to accept this, okay? So I am gonna order a pre-sentence investigation report, and I am gonna set it for sentencing on July 28th. And so someone from the Department of Corrections will be in contact, get a PSI done. I'll see you back here in person on the 28th of July, and we'll move forward, okay?
That's for sentencing?
Yes.
Okay.
Okay, so it's not that far off, and it'll give me a chance to either confirm any questions I have to be able to accept this agreement, or to let you know I can't accept it, and this is what I'm going to do, okay?
Okay.
I appreciate it.
Judge, I'm sorry.
Ma'am, hold on. I don't know who you are. You need to talk to Mr. Nguyen if you have a question.
People can just talk to judges in courts. That's a thing. All right. She doesn't have anything.
All right. Anything else, Mr. No, you're on this price. Anything else?
I don't believe so.
All right.
All right, guys, we did it. Please go and make sure you get your 2 black belts today. It's important that you know how to take care of yourself and never, ever, ever stiffen up when an officer is arresting you. Just go with it. Thanks for coming out. I hope to see you again really, really, really soon. Bye, guys. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her street sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Street tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no